We're suing PayPal and Honey. GamersNexus is the lead plaintiff in a class action complaint filed against PayPal and its property, Honey. The putative class action is already filed, and we're suing PayPal and Honey for 3 things. 1, conversion. 2 is tortious interference with contract. And 3 is unfair and deceptive trade practices. We filed this in collaboration with consumer class action firm CPM Legal on behalf of those affected by the actions of what we believe to be anti-consumer behaviors that harm not only reviewers, but consumers directly. We started working with CPM Legal about a month ago, and in the time since, multiple complaints have been filed, including one by YouTuber Legal Eagle. And to be clear, our lawsuit is a completely separate filing. We're not joining theirs, we filed our own. We must have been working on this around the same time. So as for what happens, they may get combined, and we'll cover some of that with CPM's lawyers later in the video. To take this one step further, at the conclusion of this case, if it goes that far, whether that is a win, a settlement, or a loss, GamersNexus will make a substantial contribution to consumer rights organizations, including the PIRG, or Public Interest Research Group, which protects consumers, particularly in warranty scenarios, and archive.org, among other respected consumer protection organizations. We may not legally be able to share any potential settlement details in the future, so I'll just say this. The amount we donate will be, at a minimum, higher than any amount of money, hypothetically, that GamersNexus LLC would receive as a direct financial payment from that settlement or that court decision. That is how much we believe in this. We strongly believe that consumers need a voice, and we are going to help provide this voice. This video features class action law firm CPM Legal, regular GN Legal correspondent Vincent and Wendell of Level1 Techs. They'll tackle topics of myths about class actions that harm consumers, unfair and deceptive trade practices, and discussion of cookie stuffing technicals.
And GamersNexus can represent those people as a class representative plaintiff because, as we talked about before, in the mechanics of a class action, they've been harmed in the same way by the same practice.
And so the second mechanism that is crucial to treble damages.
Okay.
Treble damages is basically getting an award in the form of a penalty against a business for 3 times the actual damages.
But as soon as the Honey thing happened, without I didn't tweet about it or do anything, but I happened to notice some of the affiliate numbers for those connections. The line went up substantially, and we're basically small time. I'm just a rando.
Here's what's going on. Honey purports to be a deal-finding solution. It's a browser extension. It was promoted by several influencers and YouTubers over the years. We never ran ads with Honey, and we never worked with the company. However, we know a lot of our viewers have used the extension and have been exposed to those advertisements from others. A recent thorough investigation by YouTuber Megalag suggested with supporting evidence that the extension has been silently and secretively swapping affiliate codes before checkout on allegations in Megalag's video. It also claims that end users may not even be getting the so-called best deals as the extension claims, hinting at possible collusion between some merchants and the extension. Honey is alleged to snipe referrals at the very last second, with the allegations stating that they steal that money, despite fronting none of the cost to thoroughly evaluate the device you purchased. But worse, we think this hurts consumers directly, and that's why we're involved. Based on the allegations in the complaint, there's potential direct harm to consumers by the extension itself. Based on information and belief, Honey may have withheld the best deals and coupons in a way that reduced discounts owed to customers and benefited retailers and merchants. Large content creators make their money through many means, and this is why many large content creators won't necessarily spend the time to get involved in this. Once a business scales to the size of GamersNexus or other large YouTubers, the affiliate revenue can quickly become less exciting, but still relevant as compared to other revenue streams, such as merchandise sales or advertising sales. Getting an affiliate link is quick and easy. It's often the only way that individuals can make money from their blog, social media posts, enthusiast websites and forums, or small businesses. That is, when third parties don't interfere with it. And this is dear to me because this is where we used to be when GN was small and I was running the website, reviewing computer hardware out of my childhood bedroom in my mom's old house. So I remember what it was like. And while we are fortunate enough to no longer entirely rely upon affiliate revenue, to survive. We won't abandon those of you with goals and aspirations just because it's not affecting us as much anymore. So, to take on this investigation, here's what we need from you. If this is personal to you, or if you want to see these mega corporations held accountable for their actions for a change, then we need your store support. If you were ever going to buy something from our store, now's the time. We've just listed a brand new honeypot foil t-shirt on store.gamersnexus.net. In order to help us soak this ongoing cost, we've launched a pre-order for these gold and silver foil t-shirts. The back of the shirt has a milestone marker for us, which is a permanent reminder of the case number, making it easy and transparent for you to follow up on what's happening and commemorating the biggest investigation we've been involved in yet. The back also includes a tiny honeybee flying away, surrounded by honeycomb patterns. The front features a broken wireframe polygon honeypot that's been smashed to pieces. Spilling out of the digital wireframe honeypot is a pool of gold foil honey. GN is taking on substantial time commitment to contribute our investigative skills and our technical abilities to support this case. Even though CPM Legal funds itself through contingency, we still have outside legal costs and we still have outside consultants. Plus, I have been cranking my personal hours up to around 100 a week to make sure we can still run the website and the YouTube channel as normal with reviews, while also taking on this important responsibility. We'd normally wait till we're closer to production to launch these, but because we're moving fast on this, and we've already started investing substantial time digging up materials to supply CPM Legal, which is leading the charge with their experts, we've been really impressed with them, we're putting these shirts up for pre-order early. Each shirt will also include a limited parody playing card in the spirit of collectible card games. The card is a foil honeypot with this ability. When honeypot is cast, create 2 treasure tokens for opponent, and then immediately take control of them. We even included some flavor text. When the powerful artisan warlock was commissioned to craft treasures, he realized something devious. Why not just keep the treasure too? You can pre-order these items together on store.gamersnexus.net. Thank you for your support. We can take on these and other consumer advocacy efforts because we are so heavily funded by the audience and minimally by big mega corporations. This hurts consumers by the following. 1, diminishing the possibility that new solo reviewers and upstarts make it to the stage that we're at, effectively pulling up the ladder and gatekeeping consumer advocacy. This is inherently bad for you all. It is bad for the consumer if that leaves people of a certain stature and larger as being the most viable. Second is it increases the chances that smaller and medium-sized creators compromise on their ethics and values and sell things like fully paid for unboxing videos that sort of pose as an independent review, or they just increase the count of invasive ads. Third, it increases the chances that larger reviewers and publications can monopolize their dominance and the review business, which we think is bad, despite being at a size where we could exploit this too. So back to the lawsuit. CPM Legal is leading the filing. They have been enormously helpful. I've learned a lot. They are extremely good educators on how all this works, and they will be joining us in the back half of this video, along with Vincent, Augusta, and again, Wendell from Level1 Techs, whom you all are likely familiar with. But class actions are a powerful tool. There's a lot of cynicism about them, but the reality is that they are one of the few very effective tools at potentially setting a precedent for a type of behavior and enforcing better behavior through painful cost, and that would be both through legal and settlement. We have to work within the system we have. Let's get into the consumer impact before we get into the filing itself. There are a few key ways that content creators make money on the internet. It's crucial to understand some of these at a base level to understand the context of the rest of this. And these methods of making money are what create the, we'll call it, free content that you're able to get access to. Sort of asterisk there's trade-offs, but it is largely free content, and that's goes back as far as the internet. So the way that reviewers like us and others make money can include these. First is affiliate linking. That's what we're talking about today. Second is AdSense, such as YouTube or Google, or other ad networks. These would include the skip ads and the banner ads on YouTube. They pay relatively low. They're sort of bulk buy ads. You don't do your own sales for them. The ads just get placed by the platform in this case. The third is direct ad sales. So that would include pre-rolls and post-rolls. When you hear us say this video is brought to you by so-and-so and it's rendered into the video, that's a direct ad sale. And then the fourth common one these days is merchandise and product sales. So those are the specific ways that we make money. And some creators also make money through other ways. They might sell fully paid for videos. These are sponsored integrations. The entire content is bought and paid for, and we disagree with this. It is their right to make money that way, but these are videos wherein the company largely controls parts of the narrative. They may pitch the concept as a whole, and the video effectively amounts to maybe like a paid unboxing type of thing. So we view these as ethically unacceptable for a review publication like us, but if they want to make money that way, that's their choice. Some companies also sell testing or independent analysis services. Same thing here. We don't, for the same reasons as we don't sell fully sponsored, paid for content because we think it's too much conflict. Now, regardless of what we believe is right, the key is that new content creators really only have one solid way, in my opinion, of trying to make some money. And when I say new, I mean brand new, just created their first attempt at consumer reviews. And that way is affiliate linking. AdSense requires you to hit a certain size and view count in order to qualify. That could take years of work. Direct ad sales took me years of work. They require stature, views, robust infrastructure for billing, selling ads, invoicing, potentially contracts. And you might not be able to get there without investing heavily into your channel or website or your enthusiast forum. Merchandise and product sales require large upfront investments, logistics, design talent, things that aren't necessarily available for a small creator. Now, there are print-on-demand services, and some people do choose to use them, but these have a lot of downsides, such as no customization of the product itself, generally low quality, generally pretty low margin, and regardless, this is technically an option, it's just not a great one, and frankly, a small creator is probably going to sell 0 of their own products or very close to it until they establish a very large following. And that leaves affiliate as the easiest avenue for a new consumer advocate. So that's someone who is closer to a consumer than really anybody else. That's why I care so much about this, because that's where I was. And affiliate is how I made a lot of my income in the early days of GamersNexus. We might not have made it to the powerhouse position we're in today without that. Reviewers of all sizes, including with 0 followers, can make a percentage share of revenue from products that are sold from clicking on their links, ideally after they have reviewed and analyzed the product and provided a useful opinion. Now, this percentage has a big range depending on the platform and the retailer. So those who use affiliate links scale all walks of content reviews. It can go from influencers with whom we sort of vehemently disagree on their general ethos and approach to things and how they use those links to effectively link spam, up to the honest upstart reviewers who may one day follow in our footsteps. So imagine a hypothetical scenario where there's someone right now who is working in their garage on a piece of hardware they just bought at Best Buy, working in their bedroom, trying to film a video, just like I did when I started. And in a world where that person's affiliate commission is getting sniped at the last possible moment by injected cookies from a source that did no work to garner a sale, then the content creator has a few options. They could fold due to lack of funding. They can just stop. It's a lot of work to do this in addition to a full-time job. If they grow enough to sell direct ads, they could sell direct ads, but they might not be able to continue making those sales because they won't have the affiliate data to back up the fact that they were successful. This is really key, and a lot of people overlook this. Affiliate can be used for all kinds of things, and one of those is proving to an advertiser that you provide value. And when you're small, the most reliable way to prove value is showing those numbers. If they grow, in this third scenario, they'll need money to do it full time, and they might have to sell their values and their ethics and compromise in order to bring money in. This could be such as by selling ads to shady CD key websites or companies that rent computers. Now, the fourth consideration is they might compromise and go for fully paid endorsements disguised as reviewer or consumer material, but really it's a glorified unboxing. They were paid to open that box and be excited about it, and that's not good for consumers either. And then finally, fifth, they might more readily succumb to pressure from sponsors to shape their content because they'd be more reliant on a single source of income without that balance from something that's more neutral, like affiliate, to help weigh things out. It's of course possible for someone to be unethical with affiliate links. But the point is that a diversification of revenue maximizes the chance that an ethical reviewer can support themselves. This can also result in more invasive and abundant advertising. If reviewers try to make up for a revenue difference by inserting more ads throughout their video, it's annoying for everybody, it introduces more direct conflict, and that's just not good for the consumer either. Now, while at first glance, this may seem like a big creator problem, it really is the opposite. We're fortunate enough to no longer fully rely on affiliate. It's still an important part of the revenue stream, but we're not at that small stage anymore. And we won't abandon those of you with your own goals and your own aspirations just because it's not affecting us as much anymore. Now, as we get deeper into this, we need to address the comments made by a channel much larger than ours because those comments and statements directly conflict with this entire video and with our beliefs at GN. This is not a video about Linus Media Group, so we'll keep this very brief. Linus recently in a WAN Show episode said the following regarding why they did not make a video when they found out about the way Honey works years ago, in response to how he believed he might be perceived if he had raised awareness to Honey's actions when his team discovered them.
Everyone's mad at me. It's that simple. I'm spreading the word for the smaller creators. That argument doesn't save me there, and it's not going to save me if I tell people to uninstall this extension that gets them a better deal so that smaller creators can get their affiliate revenue. Are you kidding me? There is just no way that I make that video and I don't end up hanging from the nearest tree.
Well, that's the video we're making right now. And if that were to result in backlash like he thinks it would, then so be it, because we think it's the right thing to do. We're not going to have this mentality where just because something would disproportionately be less impactful to us these days at our size, we don't talk about it. It would benefit us, but that's not how we're going to do things here. And it's just unbelievably disrespectful to all of the solo people and all the small companies who are affected by this, especially in a disproportionately bad way. This is an area where I fundamentally disagree with LMG Linus's take on this situation. He's free to have his opinion, but we feel his opinion is harmful to the consumer and is harmful to newer reviewers and consumer advocates, and we haven't forgotten where we came from. There's a lot more that could be said here, but let's get back on topic. So now that we've explained how this hurts the little guy the most, it's time to get into the filing. To quote our filing, quote, PayPal uses every possible artifice to get the consumer to click on their artificial referral button to steal affiliate commissions, end quote. The putative class action also states this, quote, Plaintiff GamersNexus LLC, individually and on behalf of all others similarly situated, brings his action against defendant PayPal Holdings Incorporated and PayPal Incorporated, defendants seeking monetary damages, restitution, and/or injunctive relief for the proposed class and subclass as defined below. Plaintiff makes the following allegations upon information and belief, the investigation of their counsel, and personal knowledge or facts that are a matter of public record, end quote. The suit then goes on to detail the browser extension Honey and what it does. It later states this, quote, defendants through the Honey extension unlawfully supplant this system of lead generation by stealing the commission during the point of sale. Honey systematically appropriates these commissions by replacing the content creator's cached affiliate URL snippets with their own. Plaintiff and the class would generate the sale, then while the consumer was checking out, Honey would covertly replicate last click attribution to receive the commission. This cookie stuffing scheme wrongfully captured millions of dollars in affiliate marketing commissions. By this complaint, plaintiff seeks to remedy these harms on behalf of itself and all similarly situated individuals whose commissions were stolen, end quote. Now, the next section goes into more backstory of how this all functions, and this next part is particularly interesting. Quote, consumers download the PayPal Honey browser extension under the promise that Honey will search the web for the best coupons to ensure consumers pay the lowest prices when checking out with e-commerce merchants. Honey then partners with these e-commerce merchants to give them control over the content hosted on the Honey platform. For this control, Honey receives a 3% commission applied to each purchase a member makes on the merchant's site. After this affiliate network partnership is established on information and belief, Honey deliberately withholds higher value coupons, directly contradicting Honey's promise to consumers, end quote. And that's the key to all of this. So not only do we believe that the actions of PayPal and Honey directly harm consumers and consumer advocates, but based on information and belief, they do not even offer consumers the best deals as they claim that they were offering. So the filing alleges that Honey withholds these. This could also help large merchants by reducing the amount discounted by not giving the customers the best deal as was promised. The filing continues, quote, Honey is purposely designed to exploit last click attribution. Honey stuffs customer cookies to steal affiliate commissions or charge merchants commissions, even though Honey did not refer a customer to the merchant's site, end quote. Now the filing makes these further claims. Quote, defendants systematically steal commissions from content creators that promoted the merchant's products and drove customers to their e-commerce stores. Plaintiff GamersNexus has worked since 2008 to review products and provide valuable content to viewers through their website, YouTube, and social media channels. GamersNexus has created, at the time this was filed, 3,033 videos, which have been viewed 684 million times. Creating such useful content has garnered GamersNexus 2.4 million subscribers. GamersNexus has spent substantial time and money developing a community of viewers that support it. GamersNexus has spent substantial time and money reviewing products for which it provides affiliate links. As for the causes of action, they include counts of conversion, tortious interference with contractual relations, and a violation of the Unfair and Deceptive Trade Practices Act in North Carolina. We'll have lawyers explain the nuances of each of these momentarily, but to start with the filing itself, it reads this. Quote, PayPal intentionally and substantially interfered with plaintiffs' and class members' personal property by usurping their commissions and referral fees. It calls PayPal's actions directly hostile to class members. Then, in the tortious interference section, it states that PayPal is liable to the class for damages in an amount to be determined at trial. For unfair and deceptive trade practices under the North Carolina UDTPA, it states that the class is entitled to an injunction and recovery of actual damages trebled, plus attorney's fees and other costs of this action. So the lawsuit aims to investigate questions of whether PayPal and its Honey extension were built and maintained in such a way that PayPal is, as alleged, unjustly enriched, and that is among other questions. We think this is worth doing. This is about the review community at large and what's best for the consumer. Now we're gonna get to the special guests. We have 3 people joining for this. We brought on different experts for different areas of both law and technicals to better understand what's going on and try to put it together for everyone. So we'll have Wendell from Level1 Techs on. He'll talk about some of the specifics of the technicals of cookies, but also how this whole Honey PayPal situation has affected him as a content creator, and also how he thinks it affects consumers. We will additionally be joined by Vincent Augusta, who will be speaking to some of the consumer rights issues, and specifically the Unfair and Deceptive Trade Practices Act. So he's joined a lot in the past to talk about consumer rights issues, warranty problems, things like that. And then finally, we're bringing on law firm CPM Legal, which focuses on consumer class actions. We need their help to explain how class actions work. It's a very specialized area of law and it requires specialized understanding. And we're not experts in it, so we brought on them as experts. So Tom Lozier from CPM Legal will be joining first. He was part of the team that prosecuted and won the case against Volkswagen previously for the diesel emissions, you might remember. And in that case, it led to a $15 billion payment. And this included individual consumers getting anywhere from around $12,500 or so, all the way up to around $44,000. So this is a great example of one of those situations where a class action actually paid out a huge amount to each consumer affected. It really depends on what the class action is. CPM Legal also previously won a class action where banks were reordering transactions in a way that would bust the bank account balance first, if it is going to, which would then allow them to hit the consumer with multiple successive overdraft fees in what I think is one of the most devious, evil ways to hit a consumer, because they basically, if you're going to overdraft on the last charge because it's a big charge, but you had 10 other charges that day, they moved that one, in that case, to the front, then you get hit with 10 overdrafts instead of 1. So he was part of the team that pursued that. they won and they were able to change how that happens, get a precedent set for how it's treated under law, and claw back some of the money. So let's get over to that discussion with Tom Lozier, then we'll get to the other two. All right, so now we are joined by Tom Lozier, who's the co-managing partner of Cachette, Petrie, and McCarthy's Seattle office. And Tom, you and your team, you're working on the class action filing that's already been submitted. Let's start with, so I have a lot of questions about class actions in general and how they work. When and why might someone use a class action, and where does it excel, or where does it sort of best serve its purpose? Or maybe even just defining what you think the purpose of a class action is.
Sure. So the class action was created by what's called Rule 23. It's Federal Rule of Civil Procedure 23. And it's only about 60 years old now. And it's a mechanism that was created to handle the situation where there's a great many people who have been subjected to the same practice, but each of them has only been hurt in a relatively modest amount. And because the damages for each individual person might be modest, that individual person might not have, or usually doesn't have, the incentive to go hire a lawyer, to pay filing fees, to pay expert fees, and prosecute a case where they'd only get a small amount of damages. So a perfect example of that would be, let's say in a cellular contract, you have an agreement where you pay a certain amount of dollars per month. And let's say that some company was charging you what they called taxes and fees, but in reality, they were just tacking an extra $5 onto the bill and saying it was taxes and fees. And they might do that by saying, well, it's our fee, right? So it's taxes and fees. But clearly that would be a little bit deceptive, because you're looking at that saying, oh yeah, I agreed to pay $50 and there's $5 in taxes and fees. Now, if you learn that that's a deceptive practice and it's $5 a month, you might say to yourself, wow, do I really want to go hire a lawyer for $5 a month? Why don't I just switch to some other company?
Yeah.
So a perfect environment there for the class action is, look, that may not be enough for one person to bring that case. But if that company has 1 million customers, that's $5 million a month in unfair fees that are being tacked on. And that does become enough money that it's worth it to expend the resources to do the discovery, to hire the experts, to handle the filing fees. And the proof of the fraud is uniform across everybody. So if any one person can prove that that fee is fraudulently labeled or deceptively labeled, then everybody can get the recovery, because the relevant facts showing liability are the same for everyone. So that's the scenario where class action works really well. If there's a uniform contract, a uniform business dealing, a uniform practice.
What are the stages from, filing to certifying a class is another phrase I've heard that that would be helpful to define. So can you walk me through the canonical pipeline of a class?
Sure. So the way a class action usually starts is somebody comes to us and says, hey, I feel like I've been cheated, or I feel like this is unfair. And they tell us about a practice. And then we'll look into it, we'll investigate it, we'll see. And what we're investigating is, one, has that person been treated unfairly? And two, are there lots of other people like that person who have been treated unfairly the same way? And if those are true, then the basic backbone of a potential class case exists. So following our investigation and looking into it and really getting a good determination as to whether or not there truly is an unfair practice warranting a class case, then we would file a case. And when you file a case, it is from the start what we call a putative class action. That is, we're bringing the case with the intent to make it a class action. But on the day we file it, it's only action on behalf of the person who has filed the case for us. So it's an individual case until the case gets certified by the judge to be a class action. And that's a difficult step and a tall hurdle. So we file a case with the allegations. The next step is the defendant usually will file a motion to dismiss. And in a motion to dismiss, the defendant is saying, look, even if what they say is true, there's no basis in law. So assuming we get past that hurdle, then we get discovery.
Okay.
And discovery means we get to ask them for the relevant documents, and they get to ask us for the relevant documents for what we're saying. So there'd be a period of discovery where we look at the documents and the evidence that relate to the allegations. And then we'd file a motion for class certification. And in that motion for class certification, there's set requirements of Rule 23 that we have to show. For example, we have to show that there's a lot of people involved, numerosity, right? We have to show typicality, that is, that the individual that we have as the class rep is typical of everybody else. We have to show adequacy. We have to show that that person doesn't have anything about their experience that would be disqualifying or render them different than the other people. And we have to show things like superiority. That is, the class action is the best way to do this. We have to show predominance. So these are all legal requirements that Rule 23 has. So we argue those to the judge. The defendants say why we haven't met one or more of those requirements. And then the judge would decide whether or not the class should be certified. And only if the class is certified does it then become a class action. Everyone says, well, I filed a class action. Well, no, you filed a putative class action, and the judge is going to decide whether it can be an actual class action.
Connects to another topic I had a question about, which is what happens when there are multiple people filing similar or maybe the same type of complaint for a class action, where maybe in different states or just multiple parties who are affected and it's all kind of happening at the same time. So how does that work? How does that resolve? Because I guess ultimately it would seem only one maybe goes forward, or they combine, or what's the process?
Well, you hit it on the head, and there's two different processes depending upon whether or not cases are all filed in the same place or whether or not they're filed around the country. Right now, in the Honey case, for example, I believe that all the cases that have been filed in the Northern District of California in San Jose, where PayPal is headquartered. But there might be cases filed in other districts. So if there are cases filed in other districts, then there's a process for moving a case to the district of the defendant, if that could be agreed. And there's also a process if people don't agree on where it should be. And there's a whole additional court system called the Judicial Panel on Multi-District Litigation, the JPML. And in situations where there's multiple districts with cases, there's a motion filed to the JPML to consolidate them all in one place. And the varying interests, the lawyers with the different cases, will go to that hearing and they'll argue where it should go. And then that panel decides where all the cases should go to a single court for pretrial purposes. And all the pretrial matters are handled in that court. And then if there's still disputes remaining, the cases get sent back to where they were originally filed. But usually they get resolved in whatever courts it's assigned to. That's the scenario where there's cases across the country. Where everyone is filed in the same place, the cases generally get consolidated. And that's what's happening right now in the PayPal Honey case, is that there'll be a motion, there has been a motion filed to consolidate right now I think there's 3 or 4 cases on file. They'll get consolidated before one judge. Usually it's the judge that had the first case, right? So you can't have judge shopping, right? So what happens is that whoever filed the first case, it gets assigned randomly to a particular judge. And then every case would generally, not always, but generally get assigned to that same judge.
Okay.
And then that judge will entertain a motion or there'll be an agreement. So once that happens, either all of the lawyers involved in those cases on the plaintiff side get together and decide on a leadership structure or who should lead the case, or they don't agree and there's a motion for leadership where each one tells the judge why they should lead the whole case, and then the judge decides. The judge can pick a particular group or can pick individual attorneys or can build their own a team or combined team of whoever the judge.
The Avengers of class action firms.
Exactly. So once that leadership is established, then the case moves forward under that leadership. And that leadership structure controls the direction of the case from the plaintiff's side. One thing to remember is that when you're on the plaintiff side of a class action, we don't get paid at all or get our expenses covered unless the case is resolved. And even then, the judge approves any fee in every case. and decides what's fair, reasonable, and adequate under the circumstances. And so because of that, a case can be very expensive to prosecute, millions and millions of dollars. So sometimes the courts, recognizing that, will have several firms to kind of spread the costs, so that if the judge ultimately decides or a jury decides that the case shouldn't go forward, no single firm has been
wiped out, basically.
Yeah, basically.
We'll get into some of the specifics on the filing in a moment, but staying on the broad topics for a second, gets into some of the cynicism towards class actions in general, I think, where we'll see I don't know, just one of the comments that I'll see when we report on some class action of the tech industry is, oh, great, I can't wait to get $5 in 6 years, right? And so there's sort of that side of it. Or the concept, which you've already basically addressed, of this is the lawyers receive all of the money and then there's nothing left for the actual class. So, I mean, speaking to that, can you help sort of address or dispel some of that mentality?
Sure, absolutely. There are some class action cases, a lot, particularly in the financial sector, have involving securities, where what somebody recovers is based upon how much of a security they own. So let's say there's a case where somebody makes deceptive statements, and as a result, the value of a share of a stock went down $5 per share. Mm-hmm. Right? Now, somebody like a hedge fund or a pension might own 10 million shares. So their damages are huge, right. $50 million, right? But somebody who owns one share, their damages are $5, right? Or say you own 100 shares, and the loss was $1, right? That's $100, right? So what people see sometimes is that, because they own very few shares and there's a securities case, they might get a check for $5 or $50 because of this class action. You're like, wow, what a waste of an envelope and things like that. So that does happen in those cases where there's some denomination like that. The consumer cases are usually different, and Volkswagen is a great example of that. In the Volkswagen case, people who owned the cars that had the defeat device, the cheating software installed on them, they generally received the value of their car in 2015 when the fraud was discovered, even if they kept driving it until 2019, which they did do. Plus, they received fraud damages, which were thousands of dollars, $3,000 to $8,000. So I know folks who happen to own a 2009 Volkswagen Jetta TDI that might have been worth $3,500 or $4,000, and in part of the settlement, they got $12,000 for that car when they turned it in and got it back. So in consumer cases, because the judges are involved and they have to approve any settlement or resolution, they really look closely at, does this provide something meaningful to the class?
There's someone, broadly for basically any class action, if there's someone kind of watching this go on, or even take PayPal Honey, they're watching this happen and they say, this, as it's described, I think this happened to me too. What is the process for, I don't know if it's correct to call them potentially additional plaintiffs, but what's the process for them to put their name in the hat typically?
Mm-hmm. So here's an interesting thing that a lot of people don't know, is that you don't actually have to, quote unquote, sign up for a class action, right? Let's use PayPal as an example. If a class is certified and you're in that class that's certified, that is, if you're someone who was harmed and the records of the company show that is, if the records of the company, if we can get through evidence that you had a referral token in a pixel, in a cookie that was replaced by the Honey cookie
extension,
chip going into it, then the class action will find you, right? As long as you're readily findable, right? So we will have an obligation, and the judge oversees and approves this, to have a method of finding the people and getting them the choice, because everyone has an election So in Rule 23, it's what's called an opt-out regime. That means that you are presumed in the class unless you say, I don't want to be in the class. So if a case is certified as a class action, or if there's a settlement that asks for a provisional certification of a class action, the first thing that happens is notice goes out to everybody who was potentially part of this class. And in that notice, they're told about it and they're given the option. If you want to make sure that we know about you, so that we know that there's other folks out there that have been harmed, then most plaintiffs' class action firms, and mine included, will set up a case page for any particular case. So we have a web page on our website, cpmlegal.com, related to the PayPal Honey case. And in that web page, we talk about the case, and then we have a form where you could input your information, and then we have you in the database. And that serves important purposes. One, we know who you are and you're out there. As the case proceeds, there could be an amended complaint. You could be from a state where we don't have a plaintiff yet, and we need a representative from that state. And if you've submitted your information to us and started the relationship, then, and only then, we can reach out to you and say, hey, you wanted us to contact you about this PayPal Honey case. We're at a stage where we're doing an amended complaint, and we could use somebody from Wisconsin or Illinois or wherever you are to be a class representative plaintiff.
How does this affect the consumer as well, and not just the people who produce content for them?
Well, so first of all, you're right. A lot of the little guys are people like you when you started. You're certainly not a little guy now, but back in the early days, you might have had a small audience and you needed a new camera or a new microphone or something else for your studio. And you made your income on referral links, or at least some income on referral links. And what this is going to do is that if PayPal Honey is converting referral link payments that would otherwise go to the small guys aren't going to survive. We're going to see a less robust environment, and consumers are going to be harmed by that because you're not necessarily going to get all of the honest opinions you could get. If it's only the big guys who are out there who can afford to continue even without those affiliate commissions, you don't know what their relationships are. I mean, the odds are that a savvy 18-year-old in the basement is going to give a heartfelt review of something based upon their experience that a 37-year-old former middle manager at Microsoft or at HP might not be giving that same type of heartfelt, honest review that connects with the particular audience. And making sure that we continue to have a thriving ecosystem of content providers, which is one of the great things about affiliate commissions, is, as you said, there's no gateway, there's no gatekeeping effect. Any size person or company can get an affiliate link, and the e-commerce sites are happy to provide them.
Yeah.
I mean, Best Buy wants customers to come to their website, and they don't care if they're paying 3% to a mega corporation to get it, or to the 19-year-old in his basement doing the heartfelt review. They want the customer, and they are willing to pay for it. So, one of the primary purposes of this case is to let's keep this ecosystem of content producers, let's keep it thriving.
Where should people go to learn more about all of this?
So that's a great question. And what I would encourage people to think about is, look, if you feel like you've been treated unfairly by a company, sometimes there can be a remedy for that. And it's just a matter of connecting yourself with the people who can look at that for you. And, one thing that we do is when, we have a website for our firm at cpmlegal.com. And in that, we have an investigations page. And we have a list of all the things we're looking into that people have called us and said, hey, I think I'm being treated unfairly. But we also have a place on that website where you can say, hey, can you look into this? Because I don't see this on your website, but I think I'm being treated unfairly. And I would encourage people to use that resource, or the resource of any other firm that's local to them that they know about. And there are a lot of great firms in this space. But it's an easy way to do it.
That'll be it for this one. If anyone wants to learn more about the firm, we'll link all of it below. So thanks again.
All right. Thank you.
Now it's time to hear from my good friend Wendell, and someone a lot of you are already familiar with. So he's joining to talk about not only the technicals of how cookies work, but also, again, how consumers and creators alike are impacted by what Honey is alleged to be doing. Okay, so now we are joined by Wendell from Level1 Techs. Last time Wendell and I were working on something that was probably on the Intel 13th and 14th gen stuff.
It's still ongoing. There's still people suffering with that.
Yeah, the suffering is never ending, especially for Intel. So on the Honey PayPal subject, I think it would be helpful to get some of a technical breakdown on some of this stuff. So can you give kind of a broad definition of what really is a cookie to begin with?
A cookie, it dates from like the primordial internet when the World Wide Web was nascent, and so it goes back, and we've built a lot on it over time. But basically, when you go to a website can give you a token. It's usually a really long number, but it could be any arbitrary string, and some cookies can be really large, and you can have more than one cookie. But that's how the website can uniquely identify you. And so in the beginning, it was just to identify a visitor, or maybe you would click something on a web page, and when you come back to the web page later, it needed a way to remember. So it would store a little bit of information on your computer. And then advertisers would use that for ad tracking, but it was also used a lot of the time for authentication. So if you would, log in to check your web-based email, for example, maybe you don't need to log in with your password every time. It would give you a token, and your password wasn't stored in a cookie or anything like that, but that token was a big, long, randomly generated thing. And if you showed up to a website with that, the website could read the cookie back and say, "Oh yeah, I remember you. Here, let me give you your inbox." And
Right.
so it was really useful for those sorts of things. So you don't have to enter your password every time. And actually, a lot of the time, like with Google and like a Gmail security and that kind of thing, it's actually a little bit more secure because your password is based on not storing that in a cookie, and you want to have the authentication stuff actually based on a randomly generated number in your cookie, and then your cookie also has some stuff in it to do with your internet connection. So if your cookie stays the same but your internet connection is different, or something about your browser is different, that will be a flag to Google that maybe something bad has happened, and maybe it should force you to re-authenticate. So you have your cookie that it remembers you from, and then maybe it also tries to check something else. But there's lots of different uses of cookies, and you'd be surprised at how many are stored on your computer from basically every website you visit.
How about cookie stuffing? If you were to define that, how would you lay that out?
So cookie stuffing is a somewhat older term, but it is when you have a program that sits on a computer and looks at the cookies that are across all your websites and manipulates them. The browser actually has a ton of really good security built in. So if you're on website A, it can't read website B's cookies. So if you're on Gmail, it can't read eBay's cookies, and eBay's cookies can't read Gmail. But again, advertisers, Google that bought DoubleClick, and so if you look and it's like, wait, what are all these cookies from DoubleClick? Every website I go to has a DoubleClick cookie. Well, those web pages loaded an asset or a resource or something from that domain, and so Google can kind of follow you across. Same with Meta or Facebook. It's like, oh, there's a tracking pixel. Sometimes you've heard that. And so cookie stuffing is when you have a program that's sitting on the computer, because you can't do it from a website, sitting on the computer manipulating the cookies that are actually stored in the browser to maybe change some things about where the traffic came from. So at a very basic level, some of the very earliest cases that really impressed on the vernacular the term cookie stuffing came from eBay and eBay fraud, because eBay has historically paid really great commissions. And so folks would write malware, and then just people randomly using eBay and having a particular piece of malware on their computer were paying some rando somewhere that had written malware for no other purpose other than to just, it's like, hey, here's a dancing girl that sits on your taskbar.
Right.
I get paid by having an eBay commission or an Amazon commission or something from that. And so that was a whole thing for a long time. And then the Department of Justice got wind of that, and it turned out millions of dollars were
Oh
involved.
man.
And so yeah, so those are some pretty famous court cases. And so cookie stuffing is where you stuff somebody's computer full of cookies in hopes that you are going to get some sort of affiliate commission or something like that. Fortunately, unfortunately, it's usually pretty easy to identify somebody from that now that we know to look for that, now that we know that people are harmed. But when big corporations do it, it maybe flies under the radar a little bit more. Really, a more precise way to describe it is that it's just cookie manipulation. And so someone the malware, the software now is really really sophisticated or tends to be really sophisticated, and so somebody looks at that and says, "Hey, we'll just do that."
So famous examples. You have the eBay one. Any other famous like things you know of where cookies as a topic came up in some kind of
I
case or
think
something?
I think what Aaron Schwartz was doing. So you remember Aaron Schwartz from MIT, where he was downloading a lot of journals from, from the network at MIT, because MIT's network was whitelisted to be able to download a lot of academic journals, and he wanted to rehost those.
Hmm.
And he was bullied, in my opinion, by the prosecutor and law enforcement. It's like he'd committed some really insanely heinous crime, and part of that, depending on where the documents came from and some other like fine technical details, one aspect of that was cookie manipulation.
Hmm.
And so on the scale of like eBay fraud, where yeah, probably law enforcement should do something to, the other end of the spectrum is like Aaron Schwartz, and it's like this is really more civil disobedience. Like this is maybe a civil matter, not a
All
criminal
right.
matter. You've got the whole spectrum of things in just terms of cookie manipulation. Like which thing is it? What are you trying to do? Are you trying to like steal from somebody? Are you trying to manipulate things? Like, are you trying to steal from creators? Or are you trying to steal from companies? So in the court cases that have been up to now, mostly it has been I want to steal from Amazon or eBay. But in this case, it looks like the theft is maybe a little bit more diffuse.
How about for what you know, I guess as a broad topic about how honey works? Any additional thoughts on that haven't really been discussed much yet in media?
One of the most alarming things is not just the cookie manipulation. So if you have a browser plugin, the browser plugin can see all of your cookies. It could, all browser plugins that can see your cookies could steal your authentication stuff as well, which could be like, a 5 alarm kind of fire situation. But um, for the kind of cookie manipulation that we see here, it goes beyond cookie manipulation because it actually opens up another browser, and that creates a lot of other traffic footprints that make it look more like it's legitimate traffic. Like instead of just having cookie manipulation, if somebody were to dig into the analytics, like say eBay, and eBay were to look in their analytics, is like, do we see organic traffic from this person? Did they load a web page? Did they click on a link? Did they do this? Or did they just show up with a cookie and do something? And so if you just show up with a cookie and do something, depending on how good your analytics team is, your fraud team is, you may look at that and say, oh, something nefarious is going on here because there's not the associated traffic you would normally have from someone doing this thing organically. And what it seems like Honey has been doing with the open a browser tab and do some stuff in the background, that seems like that's more to make it seem like normal traffic versus strict cookie manipulation. Because if you just need to do cookie manipulation, you really don't need to do that step in order to manipulate the cookies that are stored as part of the site. So I'm kind of surprised that that step happens, and it'll be interesting to see how they defend that. In the court case, like the technical lawyers will look at it and say, okay, why do you do this? And then they'll have to come up with some reasonable explanation for why they do that. And it's going to be interesting. It's going to be an interesting explanation. I can already tell you.
Yeah. Yeah, so you're talking about how this was shown in the Megalag video, but it can like in my words here, sort of discreetly slide out a tab, pop the cookie in, and
Yeah.
yeah. So then the question becomes if that becomes registered traffic as basically like a secondary hit to the site type of thing.
Yeah.
Like yeah.
Yeah, exactly.
And so then if you have, let's say, Google Ads on that page, DoubleClick or AdSense or some other whatever, any other network, uh, do they if it functions in such a way that they get additional impressions on the ads? I guess there's maybe some
Yeah,
questions there.
I think Google would flag that as invalid traffic. I think if Google were paying you for impressions, or if the browser automation does some kind of a click through for some kind of an ad that they carry, I don't know. That doesn't. I mean, maybe not.
Hmm.
But the others, like on eBay runs third party ads. BestBuy.com runs third party ads, depending on where you are,
I think
depending
Newegg
on what they're
still
doing.
does too.
Yeah, and so if you have a tab that loads those ads, certainly it is if Newegg themselves were doing this, or eBay themselves were doing this, were providing a browser plugin to do this, which is interesting now why I've been mentioning eBay this whole time, because remember the origins of Honey. That would be against the terms of service for the advertising. Like, Google does not really like you to do that kind of automation. If I were to write a browser plugin to manipulate, like and just change the affiliate link on every webpage you go to in the browser, that is not okay. Like, Amazon has terminated their affiliate accounts for affiliates for doing exactly that same kind of a thing. But apparently, if it's a large enough scale, they either turn a blind eye, or they're in on it, or
Right.
maybe that they themselves have been a victim of this, like they were, with the
eBay
the cookie
case.
stuffing. Yeah, I
Yeah.
mean, that was millions to tens of millions of dollars. So
Right.
anytime you do anything like that to programmatically manipulate a browser session, and it creates lots of invalid traffic, that makes advertisers nervous, and that makes everybody that's giving you money nervous, because is this real traffic? Is this a real person that was interested in doing this, or is this just, did the traffic for this arise from some other method? And it's amazing to me, like, for creators, like, for our audience to care about this. It's like, they care. This is amazing.
Well, so what makes you excited about that? Like, why is that amazing to you?
It really does. I did not believe that in this whole David versus Goliath in the two-tier system, that any prosecutor would actually ever care. And this is not, these are obviously civil cases right now, but in discovery and everything else that comes from this, maybe a prosecutor would care. Because I've looked at other, sort of well-meaning computer nerd types that are looking at this, and are like, no, I should have a right to this. I should be able to do ABC, XYZ. And, like, the hammer of misunderstanding and terribleness has come down in a crushing and overwhelming, and not a a fair and balanced kind of a way, and it's sort of demoralizing. And so to look at this, and to see enough law firms look at this and say, oh, wait a minute, enough people have been harmed that we could wring some significant money out of a large corporation for this. Maybe this is something we should, visit and deal with.
Right.
So that's exciting.
Well,
I
and
mean,
suddenly
I
end
feel,
users care too about
yeah,
even just browser security. I mean, like, one of the rules we generally have, and I think probably most companies, is don't install random browser extensions on computers. Like,
don't install browser extensions, period.
yeah, I mean, that is my approach to it as well. If you have some browser extension that claims to offer good deals and find coupons, and let's just say their big marketing thing is, we don't touch cookies at all, we do nothing with affiliate codes, all we do is find coupons, whatever, maybe you pay for it per month or something. Would you advise, broadly speaking, against users installing that anyway, just because, browser extensions? I mean, from
Yeah,
kind of a
it doesn't.
security.
Yeah, you don't need a browser extension to do really that kind of functionality. Like, I think it's worth being not quite so lazy to copy paste a code from a website versus something that automatically fills something out. Like, it would be like somebody coming to your house and saying, I can, for $5, I can really do an amazing job with where the grass meets your sidewalk. Like, it'll look amazing, and it'll have that little, half-inch dirt tread, and for $5 I'm going to do that. But I need to be alone in your house for like an hour. And it's like, I don't know about that.
Anything else on your side you think is worth covering here?
It's not too late to help your creators by, participating in their affiliate thing. Like, if they do something genuinely useful, and it's like, I'm going to buy this product, I'm going to make extra sure that I use their affiliate link. That makes an unbelievably huge difference. Even for, like, the really small long tail creators, where I'm going to make a video about this incredibly obscure thing that's only going to have like 7,000 views.
I mean, that's
But if
you some
people,
of the time.
yeah, it literally is. And so
Yeah.
it's just, I've posted things that have had an affiliate link that only get like 20 or 30,000 views. but it's so esoteric and it's so like this is this and this is why I use this, that it generates a pretty good amount of money for the amount of effort that I put into it. And it was just something that I wanted to share anyway. It was just like, this is a thing that I thought was really neat. And there's probably like 5 other people out there that think it's really neat. And so it's probably worth it. And then like 1,000 people buy the thing, and it's like, wow, that's pretty crazy.
And I think that's worth kind of explaining too. So, yeah, this is a really interesting part of the discussion where, from my view, kind of what you're talking about is if you're trying to balance the cost involved with creating a video, you can like it and want to do it because you like it and want to do it as much as you want, but at the end of the day, it's got to be sustainable. So yeah,
it's nice to see the audience sort of cognizant of, wait a minute, I've been like, I care, and that's awesome.
Yes, it's very encouraging to see. I think it despite the bad things coming from all of this, I do think it's a good lesson where some people who have maybe never thought to ask, how do these people on the internet make money, are now more aware of it, which is good for a lot of reasons. And one of them is detecting things like biases. So, yeah, pretty cool. Do you want to speak broadly at all to your experience with affiliate after the Honey video? Do you want to not?
The amazing thing for us for affiliate has been that like more stuff, it's like, I'm going to buy this because I want it, or I'm going to buy this because, some reason I have some reason that I need it, or I'm helping somebody with something. And so, it's not an unlimited budget. But affiliate revenue from some of the other stuff has let me buy some stuff that I probably would not have otherwise bought, which has actually led to interesting projects or interesting stuff. But as soon as the Honey thing happened, without like me, like I didn't tweet about it or do anything, but I happened to notice like some of the affiliate numbers for those connections, the line went up substantially, and we're basically small time. Like I'm just a rando, and if I noticed it, good lord, the larger providers, I mean, like how would you? Good lord, probably some large numbers there.
Yeah, you described it as a hockey stick.
Yeah. That is not. I have a feeling if that's true, that Honey is not going to want any of that to come out in Discovery, and the lawyers are probably going to have a field day.
Yeah. Yep. And I will leave that part of it to the lawyers we'll have on to talk. So
remember, a rando malware author was able to scam. Well, let's look it up.
This is eBay.
Yeah, eBay stuffing. 28 million.
Yep, I see that. 2 of them together. So, one did 28 million, one did 7 million here. Someone went to jail. Oh, the sentencing, before it was sentenced, they faced up to 20 years in jail.
So if a malware author can get away with 28 million, and PayPal acquired the browser extension company Honey for around 4 billion in 2019, what does that tell you about? Yeah. And it might have been fine if they hadn't been greedy with, like, you can have Honey functionality without changing the affiliate code.
Right. Yeah. Yeah, you can still find deals or something. So back to the copy paste from a website option as well. But last question for you. What are all the monitors behind you for?
Monitoring things. I've got a lot I need to monitor. not the least of which is the Honey integration.
That's what you should have running back there. You should just have everyone open.
Line go up.
Yeah. All right, cool. Well, thanks for joining me. And for anyone who wants more of Wendell, you can go to Level1 Techs on YouTube.
Thanks.
And finally, we'll check in with GN legal correspondent Vincent Augusta to learn about the Unfair and Deceptive Trade Practices Act and some of the specifics under that. We're going to start with some special guests here. So we'll start with GN regular Vincent Augusta, an attorney in North Carolina. He has joined us several times. He raises awareness for consumer rights. He has helped explain to you all how you can exercise those rights. And he does this because it helps people understand something that without considerable time or legal fees, they might not otherwise have an avenue to understand it, and we are happy to hire him and bring him in every time we do one of these. So, because our audience collectively puts us in a position with the GN Store to hire experts like Vincent to share their knowledge, we can make that knowledge publicly available to the consumer for free. Vincent will help break down some of these laws. He's going to focus on the Unfair and Deceptive Trade Practices Act. That is his domain in North Carolina. So let's get to that. Okay, and now we are joined by Vincent Augusta again. So Vincent's been on several times. We've talked about warranty issues and consumer rights issues, things like that with now Asus, NZXT, and there might have been, Leanne Lee when they sued for a patent case. So there's several videos with Vincent if you want to see more of them. You are, this normally is only sort of relevant to the extent that it's your qualifications, but this time there's specific relevance to you being practicing in North Carolina in that you can provide some insight to a specific North Carolina, I guess, act, which is the Unfair and Deceptive Trade Practices Act, which I have heard you say more than anything else in our videos. So this comes up a lot. And I think I've never actually really asked broadly what that is because the name kind of conveys it.
Right,
but,
it's very descriptive.
Right, so what is the Unfair and Deceptive Trade Practices Act in North Carolina?
So the Unfair and Deceptive Trade Practices Act is a piece of consumer protection legislation specific to North Carolina. So it's enacted in 1969, and it expands on the antitrust principles of legislation that came before it, such as the Sherman Act. And it's a very crucial portion of consumer protection legislation in North Carolina, the details of which I can kind of get to later on. But it's important to kind of just start fundamentally with what the Act says. And so the Act itself makes it unlawful to engage in unfair or deceptive trade practices in or affecting commerce. And so you can kind of notice immediately these terms are very broad. So definitionally, commerce is understood to include all business activities.
Okay.
Basically, however they're labeled or denominated, except for a couple of notable exceptions, one being the services provided by what's called learned professionals, so things like doctors, lawyers, and also individuals who are engaging in kind of a one-time activity, such as a homeowner selling their individual home. Courts have understood unfair to, again, be very broad, include several acts. If it violates an industry standard, if it goes against public policy, there's kind of a quote that gets used, something that's immoral, unethical, unscrupulous, oppressive, or substantially injurious to consumers, right? So very encompassing definition of unfair.
Right. How about deceptive?
Having the tendency to deceive. That is the actual legal understanding of deceptive.
Definition, the word is within the definition.
Yeah. Well, it's not necessarily the intent to deceive, which is another, it's the tendency to deceive.
Okay.
So even if it wasn't intended to deceive,
that's interesting.
Even if it wasn't false necessarily, it could still have the tendency to deceive. So if it was like a half-truth. And so the way you would go about that is that you would present facts to establish the factual situation to either a jury or a judge if the judge was making determinations of fact. And then it would be an issue of law whether or not those facts rose to the level of being
tendency to deceive.
Correct. Of being deceptive or unfair.
Okay, that's really interesting correction. UDTPA has, that's going to be the acronym to get used to. We're going to try and shorten it. Unfair and Deceptive Trade Practices Act. So the UDTPA, as I understand it, is built in a way where it can apply to developing commerce or developing commercial situations, novel forms of commerce. So can you expand on that a little bit?
Yeah, absolutely. So the language of the Act is very broad. It's quite vague, and that is, for the most part, by design. And the idea is that by having these terms, by having the activities that are prohibited be open-ended, you are allowing the application of this act going forward into novel situations. And so two kind of primary situations come to mind. The first is by having unfair and deceptive practices be very vague and expansive, you're allowing for the act to address new and novel business practices that are unscrupulous.
Okay.
So compared to, for example, if you had an exhaustive list of the activities that were not allowed, unscrupulous business owners could potentially find loopholes. They could work around kind of the perimeter of what is prohibited. And this disallows that because the definition is encompassing, and it can easily change with the behaviors of business practices. And then looking at commerce, the fact that commerce is so expansive allows for this act to be used for changing evolution in commerce itself. And so if you're talking about disruptive technologies, you're talking about new methods of giving and receiving payments, you're talking about digital currencies potentially. Right. These are things that are now still included because the Unfair and Deceptive Trade Practices Act is not fixed in a time and a place.
What about, the use of the act generally, or I don't have the correct language for it, but I guess the use of the act or the use of the claim that the act has been violated by some company. How does that typically materialize, or what are some examples of where it might be applied?
Right, so the first thing kind of looking at the act in terms of after you understand what it prohibits, the question becomes kind of, so what? How do we actualize this? How do we weaponize it? How do we use it in the real world? And so the Unfair and Deceptive Trade Practices Act has two very crucial mechanisms that allow for enforcement and effective enforcement, if you will. So the first is that the Unfair and Deceptive Trade Practices Act explicitly states that a consumer who is affected by business practices that are unscrupulous can bring a civil lawsuit against that business directly. And so we call this a private right of action.
Okay.
And so you can kind of compare it to a lot of other laws, criminal laws, for example, some other consumer protection laws, where it prohibits certain behavior, it makes certain behavior illegal, but the enforcement can only be actuated by the state or the federal government. The private right of action is very important to consumer protection because it allows more enforcement generally, is that the state is limited in their resources, they're limited in the size of cases that they can address just for efficiency purposes, whereas consumers are not. A consumer can bring a case directly for the damages they experienced and be compensated.
Okay.
And so the second mechanism that is crucial to treble damages.
Okay.
And so treble damages is basically getting an award in the form of a penalty against a business for 3 times the actual damages. And so if your actual damages are $10,000, treble damages mean you would get $30,000. And the idea is that generally speaking in the law, we only compensate people for the damages they actually experienced. The idea is to put someone back in the position they were, to make them whole. And so this is a special kind of damages in the sense that it is designed more to dissuade businesses from engaging in a behavior than it is to actually compensate someone for harm that was done.
The multiplying effect, it seems like not only helps encourage bringing a case where otherwise you might feel it is simply not worth it as the screwed party, but also, like you're saying, the dissuasion of the act to begin with. And so you had an example that I think is great to talk about, which is that of sort of a hypothetical insurance company.
Right, well, and not so hypothetical. I mean, this is one of the primary ways that I think that lawyers use consumer protection laws like the Unfair Deceptive Trade Practices Act, and it's one of the most important applications of treble damages, which has to do with insurance and bad faith denial of insurance claims. Is that if my car is insured for $30,000 and I total the car, if I make a claim for $30,000 and there isn't treble damages, then there is a very real economic incentive for the insurance company to make a bad faith denial of my claim, because they know that in order to get the $30,000, I would have to sue them, and that would cost time and money and energy, and there might be a non-zero chance that I would lose altogether. And so by leveraging that, they can deny the claim and then maybe offer to settle for $25,000.
And so they've saved $5,000 simply by denying you.
And they understand that the process itself is taxing enough where $5,000 is reasonably not worth pursuing.
Yeah.
Treble damages makes that calculation virtually impossible, because I go to court and sue an insurance company for $30,000. I'm not suing for $30,000. I'm suing for $90,000.
Right.
And attorney's fees. There's an attorney's fees provision as well for the prevailing party.
And that's a huge part of this too.
Right. So if you look at the statute, the treble damages explicitly states in the statute that upon a finding of unfair and deceptive trade practices, treble damages shall be awarded.
Okay.
So it's not actually an option. Once the judge makes the determination that as a matter of law, the acts were unfair or deceptive, they are required by the statute to award treble damages. And that's not necessarily true with attorney's fees.
Okay, and then attorney's fees is just as simple as it sounds, I guess. It's literally the fees, whatever the attorneys sort of bill.
Reasonable attorney's fees,
Okay,
yes.
yeah. Who does UDTPA protect, or what's sort of the intent of who it protects, and are there exemptions to that?
So the Act protects a very broad range of people. It protects consumers, obviously, but it specifically protects consumers at varying levels of commerce.
Okay.
It affects other business entities as well. It is not used, as I said before, kind of in internal activities. There's exemptions for internal activities. So, for example, within a company, you wouldn't necessarily see UDTPA being used if you were suing, a shareholder or something like that.
Okay.
But if you're in affecting commerce, kind of generally between two distinct parties, then the UDTPA will likely apply.
Tortious interference with contract. Where do you want to start with that?
So, tortious interference of contract is wrongfully interfering with an existing contract that two other individuals have. So an example would be, let's say, if you are selling your house and you have a buyer for $500,000, and I go on the internet and I publish horrible, defamatory, untrue things about your house. I say that your house has asbestos in it, and it's built in a graveyard, and jets of sulfur gas spew out of the lawn every so often. And because I publish these false statements, the buyer backs out of the contract. That would be tortious interference with contract, because you had a valid contract. I had no rightful means of disrupting that contract, and I acted tortiously to harm you by disrupting that contract.
Okay. Potentially to the ability to then buy it for lower than market value or whatever.
That would be the implication, is that I swoop in and I buy the house for $400,000
Sure.
now. Which again,
it's a lot to pay for something on a graveyard with radioactive waste spewing sulfur, but
I'm sure those problems will stop as soon as I buy it, right? But this is a great example of when unfair deceptive trade practices would apply, because now in that situation, I buy your house for $400,000, even if you find out about the malfeasance that I've committed. Without treble damages, you sue me, the most you're going to get is that $100,000 difference.
Right.
And so now I can offer to settle the case for $50,000, $75,000, and now I benefit from my own malfeasance. And you see this in a lot of different commercial areas. So you see this in something like systematically overcharging individuals, misrepresenting the quality or tenor of a product. You see it with bad faith insurance denials. You see it with tortious interference with contract. These are all instances in which there is, without treble damages, there would be an economic incentive to do what has already been declared as unlawful.
One of the questions I had is in something like in a situation, class action or not, where you have someone in one state affected by a party in another state, where you're kind of across state lines, I guess, and there may be laws that exist in state A but not state B. How does that all work, broadly speaking?
Yeah,
I know it's really complicated.
So what you're talking about is a choice of law issue, is that the jurisdiction in which you bring a lawsuit has a methodology for deciding what law to apply. And it is not always the law internally of that jurisdiction. And so there is a fairly sophisticated calculation that occurs. And so if you're bringing a lawsuit in one state, that state will have laws that determines if the original of whatever state you want internal law should be applied, and that calculation changes state by state.
Okay.
So sometimes in order to get the law that you want to be applied, you actually have to go to a jurisdiction that seems counterintuitive.
Okay.
So the answer is it very much depends on the facts, the circumstances, and which jurisdiction you're bringing the lawsuit.
Got it. Last one I have for you is just sort of a simple definition of tort.
A tort is understood as a civil wrong. So it's distinct from contract in the sense that a right, a claim under contract is defined by the contract terms, and a tort is kind of a civil wrong that comes from a different type of obligation, is that you have a duty to behave in a certain way from some other source other than a contract itself.
I think we've covered it pretty well, and this also serves as a great thing we can point back to when we talk about computer hardware companies in the future and unfair and deceptive trade practices. It comes up again. So now there will be a permanent reference for what does that mean, because we have joked that this is one of your action phrases. It comes up a lot.
There's a lot of plaintiffs' attorneys in North Carolina. This would be their action phrase.
Right. So that's it for this section. We'll jump over to the rest of the video now, but Vincent, thank you for
Thank you
joining
again,
me.
Steve. Appreciate you.
So this whole thing is pretty different from what we usually do, but it's important. And for this one specifically, this investigation, there's a few things that are different from how we normally do them. One is there is a legal filing involved. That changes a lot of variables. Two, this was kicked off by Megalag, and he did an excellent job in the first video. Our understanding is that he has a couple more videos coming up. You should check those out when they drop, and we'll follow it there. So sort of unlike the usual investigations that we're involved in the most heavily, where we sort of kick it off, this one was really started this time at least by Megalag, and so that's a little bit different. You should follow his content. As for our involvement, we are going to be heavily investigating this. The difference is this time it's going to be kind of a call of the law firm as to, hey, do we want to publish this now as part of our own content like we normally would, or do we want to hold this and supply it to the case to be used and hopefully later get published, depending on what sort of how the engagement works there. I'm not an expert on that side of things, but that's the big difference. The intent would be to bring it all public, but it might go through sort of a different channel first this time for purposes of the lawsuit. So that's a little different. And then finally, it's going to be several months before this is really in the next stages of this. We'll give you updates along the way, but this is another big difference. So normally in our investigations, we're just us digging into a company and we just publish it all out there as soon as we find it. This is going to be a much longer timeline, and there's probably going to be a lot more silence in between with fewer updates because of the legal nature of it. And so we're going to be waiting several months. Later this year, we should find out if it's certified as a class, who gets to go forward, who stays the lead plaintiff, who the law firms are, if it is certified, all that stuff. We'll update you then, and hopefully before then as well. Additionally, if and once it is certified as a class and this whole thing proceeds, then that's still potentially a years-long process to really get to an answer of some kind. So that's just the legal system, and it's going to take some time. But we're going to keep you all updated. Part of being involved in this is trying to learn more about it too, and how these things work. So hopefully we can give you some unique insights, and we'll get an education from the experts, and then we can try and convey that all to you. And then finally, again, to support these efforts and our efforts to bring experts on when we don't fully know a nuanced subject, like when Vincent is talking about the Unfair and Deceptive Trade Practices Act, you can go to store.gamersnexus.net and grab one of our honeypot gold and silver foil t-shirts, which features a polygon wireframe honeypot that's been busted on the ground and is spilling honey. The back, again, features a case number and what we think is a pretty cool design. And again, each of those pre-orders comes with a honeypot card, which creates 2 treasure tokens for your opponent in familiar trading card games that you then get to steal. This will help fund GN's investigative time and technical expertise as we allocate resources and staff and time to all of this, and it'll also help us fund when we need to bring the experts in and hire, for example, Vincent Augusta to come help explain some stuff for the audience, plus our own outside consultants and investigators we work with on numerous investigations now. So that's it for this one. There will be a lot more. Just be advised it's going to be a much slower update cadence than you're typically used to, but that's all part of the plan. So check back for more. Subscribe as always. Go to store.gamersnexus.net, and we'll see you all next time.